out yesterday.
Oh, okay. Well, you must have a different charge in Greenfield, because this is, these cases are not from Greenfield. I mean, what do you charge with in county court?
The same thing.
Pardon me?
It was July 12th, the same thing. July 12th when I went to Greenfield, and then they transported me, and they could only hold me for the 14 days or something. So then I had to go back to court, and then they released me, and then I have a court date for January, like the 10th, and then
Looks
the
like it's
19th.
dismissed. Looks like that charge is dismissed. If I'm reading this correctly. All right. Let me see here.
Okay.
Okay. All right, the court's going to appoint attorney Jake Wagner to represent you and enter not guilty plea on your behalf. So the bail review hearing for Friday morning, that would be February 11 at 8:30 a.m. And that'll be by Zoom. First pre-trial will be March 2nd at 1:00 p.m. That'll be by Zoom. Final pre-trial will be March the 16th, 1:00 p.m. Trial date will be April 11th at 8 a.m. Well, we set an amount of $100,000 plus your own promises, which is your promise to appear. If you fail to appear, you will be prosecuted for additional felony, and if convicted and sentenced on that, regardless of after this case, you're required to pay a service fee deposit of $171 for certain statutory required fees. You'll be under pretrial supervision of the probation department at 117 East Main Street. And if you make on your report to them, you will release them once a week or 4 weeks after that as they determine. I'm going to go random drug testing, may order, provide phone numbers for home employer, have no contact with any of your co-defendants. If recommended by probation, you'll be evaluated for substance abuse, mental health issues, and treatments indicated. You'll enroll in while under this action. You'll also be under house arrest at your residence on 801 Treewood Drive, Apartment 2. You have to be there all times unless you're working, going from work, going to and from medical appointments, court proceedings, and this, or any other court, probation officer, or attorney. You may also attend any kind of educational programming, job service, job training, etc. And if you fail to comply, then the court will revoke that law and have you done for we'll notify your attorney of his appointment. Do you have any questions on this item? All right, thank you. All right, are you Kayla D. Cheney?
Yes, but my name is not Cheney, it's Ison. I don't know why you guys have me under Cheney.
Yes, what is your actual name?
Ison.
Ison. All right, have you ever been known as Cheney?
I'm married to Cheney, but my name's never been changed on my social or anything.
Okay. All right, well, so are you related to Jennifer Ison?
That's my mother.
All right. Well, I'm going to continue your arraignment until the prosecutor's office will be here to determine what the name situation is, because, I don't know if there's another Kayla Cheney out there, or if it's a mistaken identity or what, so, we'll continue this arraignment until, I can, talk with the prosecutor's office, so we'll see about that maybe later this afternoon.
Can I ask, what, the Cheney though, I'm married to a Cheney. That's the only reason why I said.
Oh, you are married to a Cheney?
Yes, one of my papers though say Ison and one say Cheney, that's what I was telling you. because I
Oh,
didn't know.
okay. So you're married to a Cheney?
Yes, sir.
Okay, I got you. All right, well then I'll go ahead and go for it then. All right, just sounds like a mistake then. So apparently they didn't know that you didn't change your name. All right. Okay, well then, case number 22 CR 25. David Ohio versus Kayla D. Cheney. Defendant indicates her actual last name is Kayla D. Ison. She is married to a Cheney. Miss Ison, you were indicted by the grand jury of this county back on the 1st of February, along with 6 co-defendants, including Jennifer Ison, your mother, as you've indicated. And you were indicted, it looks like, in case count 25, aggravated possession of methamphetamine. Also count 26, aggravated possession of methamphetamine. 2 counts, all right. Now count 25 alleges that you knowingly obtained, possessed, or used methamphetamine in this county on or about July 12th of last year, along with Jennifer Ison, and it was over 5 times bulk, less than 50 times bulk. And count 26 alleges you did the same thing, same date, but not in bulk amount. And I believe those are the only 2 charges that she had. All right. Now, the first count, then second-degree felony, that does carry a mandatory prison term of between 3 and 8 years as set by the judge, and a fine of up to $15,000, possible license suspension 6 months to 5 years. And then count 26, a 5th-degree felony, carries a possible prison term of 26 to 12 months, fine of $2,500. Both carry a possible license suspension 6 months to 5 years. Now, you are entitled to have an attorney in this matter. If you can't afford to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form. Is everything on that correct?
Yes, sir.
When was the last time you were employed? When?
2018.
All right. Okay. All right. The court will find that you're entitled to appoint counsel, appoint attorney Dennis Kirk of Hillsborough, Ohio, to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set your bond review hearing for Friday morning, the 11th at 8:30 a.m. by Zoom. Your first pre-trial will be March the 2nd at 1 o'clock by Zoom. On a pretrial will be March 16th, 1 o'clock by Zoom. And your jury trial will be set for April the 11th, and that'll be in person at 8 a.m. Your birthday, March 28th, 1994?
Yes, sir.
All right. Court will set bond in the amount of $7,500 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'd be required to pay a deposit of $171, secure certain statutorily required fees prior to your release. Recommended by probation, you can be evaluated for substance abuse and mental health issues, and treatments indicated to roll in, fall after a pendency of this action. Not have any contact with any of the co-defendants other than your mother.
Okay.
And you'll be under house arrest if you make bond at your residence, 801 Treewood. That's apartment 2.
Yeah, that's just my mailing address. That's my grandma's, but I kind of stay. I mean, I guess I can stay there.
Where's your grandmother live?
801 Treewood, what's her address?
What's her apartment number?
Apartment 2.
All right. You have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, or appointments with an attorney or probation officer in this or any other case. And if you fail to comply, then the court could revoke that bond and have you held till further order of the court. Do you have any questions, Ms. Cheney?
Yes, sir.
All right, we'll notify your attorney of his appointment. We'll have your hearing Friday morning.
Thank you.
We'll find out who the attorney is. No, never mind, I'll just ask. All right, this is case number 22 CR 29, State of Ohio versus Drake M. Ames. Drake M. Ames.
Yes, sir.
All right, Strange, you were indicted by the grand jury on the 1st of February. And along with Stephen Debo. And so it looks like you were indicted in count 1, along with Mr. Debo, for aggravated traffic methamphetamine allegedly occurred on about February 13th of last year in this county. And she sold or offered to sell methamphetamine. And then count 2 was aggravated possession on the same date. And then count 6 alleges that on or about January 6, 2021, you knowingly sold or offered to sell methamphetamine in this county. Count 8 alleges you did the same thing on January 12, 2021. That was in the vicinity of the school zone. Count 7 and 9 allege you possessed methamphetamine on those dates. Now, the count 8 is a third-degree felony which carries a possible prison term of between 9 and 36 months, fine $10,000. The other trafficking charges are fourth-degree felonies. Each of those carry a possible prison term between 6 and 18 months, fine of $5,000. The aggravated possession charges are fifth-degree felonies, and those carry a possible prison term convicted between 6 and 12 months and a fine of $2,500. All carry possible license suspension 6 months and 5 years. Now, you're entitled to an attorney to represent you if you can't afford to hire one, or appoint one for you. And let's see, who was your attorney in your other case you had pending?
Sarah Barker.
Sarah Barker. Okay. All right, the court will appoint Ms. Barker to represent you in this matter. I'll let her not go to on your behalf in her absence. We'll set a bail review hearing for this Friday morning at 8:30 a.m. by Zoom. Your first pre-trial on this charge will be February the 16th at 1:00 p.m. by Zoom. Final pre-trial will be March the 2nd at 1:00 by Zoom. Trial date will be April the 25th at 8 a.m. in person, obviously. Bond will be set in the amount of $10,000 plus your own recognizance, which is your promise to appear. If you fail to appear, then you could be prosecuted for additional felony, and if convicted, sentenced on that, regardless of what happens in this case. If you make bond, you'll be
recording in progress.
Under pretrial supervision of the probation department, 117
Recording
Main
stopped.
Street. You are required to report to them immediately upon your release, and then once a week for 4 weeks, and after that, as they determine, undergo random drug tests and then ordered by phone numbers for home, cell, employer. Have no contact with the co-defendant. If recommended by probation, you evaluated for substance abuse, mental health issues, may treatments indicated to enroll in, follow that during pendency of this action. And you also be under house arrest as your residence, meaning you have to be at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or a probation officer in this or any other case. If you fail to comply with that, then the court could revoke that bond and have you held to a further order of court. Do you have any questions?
No, sir.
Alright. Back up. Deputy, I need to change those hearing dates because Ms. Barker's not available on Wednesdays. So we'll for him, his pretrial will be March the 3rd.
All right,
At 1:00. The final pretrial, the first pretrial, 17th at 1:00. So February 17th is the first pretrial. March the 3rd is the final pretrial.
Your
I
Honor,
have y'all.
Oh, wait a minute, Ms. Barker's there. I forgot she's on. Yes.
I apologize. February 17th, I have a hearing in Judge Beer's courtroom at 1 o'clock.
Okay, did we set, I know I said something for you the other day. Was it at 11 o'clock on those
No,
dates?
what I got was for the 24th, because the 17th I was told everything had to be moved to the 24th.
Oh, yeah, that is right. Okay. I forgot, I'm gonna be, next time I'm counting that day. All right, so what time is the first what time is it, February 24th?
Yeah, I'm in your courtroom starting at 1.
All right, so, okay, sorry, officer. All right, first pretrial is February 24th at 1 p.m.
I have a preference, sir.
Okay, and then then on the 3rd of March, we have a final pretrial for you for some other cases. Did we set those in the morning or at 1 o'clock?
1 o'clock.
1 o'clock, all right. Okay, good. All right. And we're having a bail review hearing Friday morning at 8:30. If that's a problem, let Marcia know. We'll reschedule that. All right? Thank you. All right, officer, I think we're done then, and we're going to need Mr. Hill, I believe, on the Zoom.
Oh, okay, we'll do, sir.
Your Honor, I believe that Adam King needs to be let in.
I'll get them in a minute. I'm sure there's others.
Thank you.
Yeah. I do know this, but it's in that whole thing. What is that? That is on.
I don't know, Judge.
That's it.
Thank you.
All right, are you Jared R. Hill?
Sir.
All right, matter is set for hearing on case number 21 CR 085. State of Ohio versus Jared R. Hill. This hearing is being conducted by Zoom, and is occurring from the jail. His attorney is Sarah Barber. She's occurring by Zoom, and Assistant Prosecutor King is also occurring by Zoom, representing the state. And Mr. Ballsworth is present on behalf of this probation department, and Ms. Collins is also on the screen from the victim witness office. The defendant was placed on community control in this case for aggravated, let me find it here, aggravated trafficking of methamphetamine, a 53 felony on October 6th of 2021. There was a notification filed alleging that he had failed to comply with the conditions of community control, and that was, I believe, filed on the 13th of January, and the court notified him and then set the matter for hearing, and the matter had to be continued due to conflict of the schedule, and continued until today. Now, in the interim, Mr. Hillman was indicted by the grand jury in a new case on February the 1st on aggravated trafficking of methamphetamine, fourth degree felony, aggravated possession of methamphetamine, so this will be his arraignment then, and I'll do that before we go on back to the other case. Ms. Barger, were you aware of this indictment?
I was, Your Honor, and I've actually been working with the prosecutor's office, talking with them, trying to get a global resolution for both issues.
All right, then you're prepared to enter a plea on behalf of your client?
Not today, if we could do
No,
that.
I mean, well, not guilty plea?
Correct.
Okay, so.
Thank you.
Yeah, okay, so, court will accept that. That will obviate the need for a bail hearing since you're present for this. So we'll go ahead and set this for a pretrial for today is the 8th to the 16th. No, you can't do it the 16th, 17th, and, what time?
17th, you're not here, Your Honor.
Oh, that's right, I'm not, 24th. Yeah, 24th at, 1 o'clock. And then we'll do final pretrial on March the 17th at 1 o'clock. And a trial date of April 11 at 8 a.m. Bond will be $5,000 plus OR, $171 deposit for service fees, and the same conditions as normally apply in arraignment. All right, now with that situation, then, since you're working on the global settlement, are we going to proceed here today, or do you wish to continue this matter?
We would request to continue it, however, we would ask that a bond be set, because at this time, he's got a no bond on this particular case. Would ask that a bond be set in a reasonable amount. My client does have a place to live, he does have a job, he works for Cutter Express for Nathan Ryan, who's the owner. Living at 214 Cedarwoods Drive, apartment 17 in Hillsborough. His fiance is Anastasia Phillips. She lives there along with their child, and she's currently pregnant. He is the provider.
All right, Mr. King.
The state has no $5,000 bond would be appropriate on that.
All right. Well, because this is defendant has been convicted, there is no entitlement to bond, which is one of the reasons I said it. And given the fact that the defendant was charged with the violations, and I believe there was look here and see. I think that the warrant was issued because I believe failure to report since October of 2021, and October 13th, and he was arrested either the 12th or the 13th. He listed himself at that time as homeless, and he had failed to enroll in a complete substance use disorder treatment and aftercare. And it appears that this new charge happened prior to I should say the charge in 22 CR 36 is alleged to have occurred in June of 2021, which would have been prior to the defendant being placed on control in this case. And I also note that prior to the defendant's entering plea guilty, there had been failures to report to the probation department pretrial supervision. And so, of course, we will not set bond in this matter. So it will remain the same. All right. Anything further from counsel?
No, Your Honor.
All right.
When is the probation violation hearing continued to?
Oh, good question. Let's make that March the 17th. At 1 o'clock. Unless something happens prior to that. He was accepted for the STAR program for bed date of February 16th.
Your Honor, can you put, Ms. Barker and I in a breakout room? I think there's some confusion.
All right. All
I
right.
think Ms.
Now,
Barker needs a second with client now, Your Honor.
wait a minute. I was. All right. Go ahead, Mr. King. I didn't hear what you had to say.
So I think Ms. Barker needs a second with her client now, Your Honor.
Okay.
Exactly.
Let's see here. But if there's a holder on them, they won't, as I understand it. If there's
Okay,
no holder,
okay, makes sense.
you know, so, we can find out, Drew.
Ms. Sturgill thought it'd be okay, she put it on the paperwork, but that was the case. So they had balked at it, so,
So the answer is yes.
yep.
So here's what we're trying to potentially do here, Your Honor, is the defendant would admit to the probation violations. The state probation department of defense would ask that defendant go to STAR next week and then have an OR on in the 22 CR 36 case.
Okay,
That's what we were hoping to accomplish today.
all right, well, that sounds like a good idea to me. I thought maybe that might be what happened, so, or what happened, but I didn't know how far along you guys were in your discussion, so, all right. So back, on Mr. Hill. So, my understanding then is that the defendant's going to admit to the violation of section of 21 CR 85, and the state's going to recommend that he be continued on community control with the condition that he be required to successfully complete the STAR program.
Yes, Your Honor.
Yes.
Okay. All right. Well, Mr. Hill, the allegations against you that were filed back on January 13th are alleging that you failed to report to the probation department since October 13 of 2021, which would be a violation of Rule 2 of your conditions in your sentencing entry on October 6, 2021. And the violation of Rule 7 and on or before January 13, 2022, you consumed meth and THC, which would be marijuana. Rule 15 is on or about 1/13/22, you failed to pay any court-imposed financial sanctions. And Rule 19A, that you had failed to enroll in and complete SUD, which is substance use disorder treatment and aftercare as ordered at FRS. And that was what was signed by Officer Bolzer on the 13th of January, and you signed it. Now, the purpose of the hearing today was to put on an evidentiary hearing in which the state's required to present evidence and prove to the court that you have failed to comply. And you have a right to have your attorney cross-examine the witnesses for the state and to try to bring out evidence that helps your side of the case. And you're also entitled to present evidence, testimony on your own behalf, including testifying on your own behalf if you want to, although you cannot be forced to do so. If you don't, that won't be held against you. Now, in the event that you admit to these violations, I can do one of three things. I can continue your community control with the same conditions. I can continue up with additional conditions, which could include ordering you to do residential treatment or other programming, or CBCF, which is what STAR is, or any other conditions I think are appropriate. The third and the most serious is that I could revoke your community control and sentence you in prison for 6 to 18 months and fine you $5,000. Do you understand that?
Yes, sir.
And has anyone promised you anything other than what has already been stated to get you to admit to this violation here today?
Sir.
And has anyone promised you anything other than what I just discussed with you? Okay.
No, sir.
Has anyone threatened you in any way to make you do this?
No, sir.
Right? Do you have any questions then about the allegations?
No, sir.
Do you have any questions about your rights or what would be involved in this hearing?
So I'm leaving for, if I'm admitting to the violations and I leave for STAR on the 16th, correct?
Well, if I agree to that.
Okay, I'm sorry, yes, sir.
Yeah.
Other than that, that's the only question I have, sir.
All right. Okay, anything further, counsel?
No, Your Honor.
All right, then do you admit the violations that were filed against you, Mr. Hill, that I just went over?
Yes, sir.
All right. Court then will find the defendant has admitted to the violations. Court will continue the defendant on community control. The additional condition that he enter and successfully complete the STAR program. Remain in jail until he goes to STAR, which is February the 16th. Then with regard to the other case, we're going to reschedule that then. So, is there a deputy in there yet, Mr. Hill?
Yes, there are.
Okay.
Yes, there is.
All right, officer, I'm sorry to do this. You're probably gonna have to tear that other one up and do a whole new one. I'm about to that point. I know they don't like to have people pulled out of there when they're first in there, so, and they can do Zoom, but, what I'm gonna do is move these back a ways. And I think this will do two things, Mr. Hill. One, we'll see how you're doing in terms of complying with the order I just did, and then plus it probably is going to have some bearing on what the state's willing to recommend in the future. So, I will set your first pretrial for April 21. No, yeah, 21, that's a Thursday. At 1 o'clock. We'll do your final pretrial on May the 4th at 1 o'clock, and set your trial date for May the 23rd at 8 a.m. Your bond will be changed to an OR only, and the service deposit will have to be paid within 120 days, since you're going to be in STAR, which is usually are about 90 to 100 days that you're down there. And be in the custody of the STAR CBCF and comply with STAR conditions. Now, I will tell you this, Mr. Hill, that in the event that you don't successfully complete the STAR program in the 21 CR85 case, I can tell you that the court's going to revoke you and send you to prison. Because this is, you've had several opportunities that you've not done the right thing, but the court's position is if somebody can't successfully complete the STAR program, then they're not committed to the program, and therefore it's time for prison. So that's what will happen, and that doesn't mean that you get through 90% of it, or even 95%. You get through 100%. Period. End of story. And again, if you don't successfully complete it, then the state's probably going to take a different position than they might otherwise if you do complete it. All right. Anything further, counsel?
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Are the other hearings in person, Your Honor, the next hearings?
I believe Owens is in person, and what about Peterson? Man, is that Zoom?
Zoom.
Peterson Zoom?
That's what I have down, sir.
Okay. Yeah. All right. So that's not till 2:30. So, but it'll be on the same invite. So the jail, if you want to just mute it,
Okay.
and you don't have to sign back in then. All right, this is case number 21 CR 135, State of Ohio versus Cleveland R.O.S. President of the state's Assistant Prosecuting Attorney King, President of the Defense Attorney Adam Blau, and you are Caitlin R.O.S.
Yes, I am.
Just yell or whatever.
Yeah.
Right, the defendant has entered a plea of guilty to aggravated trafficking in methamphetamine and first-degree felony. The court ordered a pre-sentence investigation, and I have received that and reviewed it. Have each of the attorneys received a summary?
Yes, Your Honor, that's yes.
Right. Take from the state regarding sentencing.
Thank you, Your Honor. State would ask that the court follow the plea agreement in this case. Restitution is $890 to the task force as joint several with co-defendant. As far as the forfeiture of the vehicle, that vehicle was titled in the co-defendant's name. The forfeiture has already been ordered and titled issued to the county commission. Thank you.
Ready? All right, Mr. Blau.
Your Honor, same thing. We asked for you to follow a plea agreement. This is her first offense. Youth often carries with it stupidity. She didn't realize the gravity of the effects on her, not necessarily incarceration, but for her personally, it's her family, the loss of children, things. I said loss as in her family is being separated right now. She's fighting hard to do that. That's a big deal to her. You're not going to see her back. Age usually comes wisdom. This is an eye-opener. The only thing we asked, we did agree to restitution, Judge. I don't want to hit the state out of the blue on this one. We agreed to restitution, but we would ask when there's a forfeiture that offset restitution, just like you shouldn't profit from it.
I thought the vehicle was titled to her as Mr. Clemens.
Correct, but what it
had
is,
nothing to do with her then.
well, what it is I guess we're asking on both sides. So whatever, when they get that, we actually had to agree to the rest. Not restitution. We did agree to the forfeiture of it. Now I don't honestly know if there's an equitable right or anything else, but it's a joint and several as far as the state's, not the forfeiture, I'm sorry, the other part, the restitution. There's a forfeiture, so I just think that it should be offset, so it's not basically double dipping on this one. There was money spent on the vehicle. I think they should get, the vehicle should apply to restitution. I will also let you know, Judge, I am just bringing this up to the state now. I don't want to guess anything to because Chelsea handled this. I don't want to do that. Did I say anything right?
I don't agree with the position of the defense counsel, Your Honor. I mean, I don't know if he's trying to say the state profit. This is my money that the co-defendants have agreed to pay back. They agreed to the forfeiture. I don't really see where we're going.
It's purely an offset, Judge.
Well, I don't understand how, because under the law, forfeiture results in the, when we plead with a specification, it results in the forfeiture of property. Very another story. Restitution is a separate component for money was spent by the drugs. Has nothing to do with the property. So it's a novel and creative argument that the courts deal with that.
It sounded good, Judge. Come on.
Yeah, it sounds great. Yeah, it sounds great. Yeah.
I'm trying.
If this was my first rodeo, I might have thought about it a little longer. So we're really going to say. All right. Now, Ms. Owens, is there anything you would like to say on your behalf?
That I have definitely learned from my mistakes that I have made, and I only want to push forward and make sure I make the right changes that I need and continue to be the best mother I can be. And you will not see me back in here. It's been a very big eye opener.
And where are your children now?
My daughter is currently in Texas under a temporary order until this is resolved. And my son, he's with his grandma right now.
He's with
He's with his grandma right now. My son is.
legal custody or?
Oh, yeah, I got legal custody. Yes, I
So
do.
he's living with you?
Oh, yes.
Okay.
Yes, my 10-month-old son is living with me. I have custody of my daughter, but she's under temporary orders down there until all this is resolved.
So where she's placed with a relative or someone?
She's placed with her grandma right now. Yes.
I know you're in the mental health counseling right now with FRS.
Yes.
And one of the things I've seen is that you have a medical marijuana card, which you've had since back in January of 2021. At this point, apparently the issue is not substance use disorder, but mental health issues. The reason I'm making an observation is because for those persons who are in actually a substance use disorder, medical marijuana is an impediment to successful treatment. It's another way of self-medicating, just like drinking. It's not really a drug, but it's a different type of drug. And so we don't permit that in drug court, and I normally don't permit it if somebody is in treatment for drugs, but you're not. So in this case, I'm not looking at it. I'll tell you, Mr. Owens, I'm really a little bit on the fence in your case because, yeah, you were being supported by a drug dealer. Let's put it just the way it is. He's a known drug dealer. Been a drug dealer for a long time. Go back to 2014. You chose to put yourself in a relationship with him, have a child with him, have other children living there, and then acting as his driver and going to drug deals. You were fully aware of what's going on. You were accepting the benefit of that. And that's a problem, I think. So I think that, quite honestly, I'm really on the fence. I was on the fence on this about whether or not I was going to give you control. But I'm going to do it. But it's going to be the term will be a little bit different than you might have anticipated. First of all, I'm going to order that you be sentenced to the term of 3 years of community control and supervision probation department under these conditions. Must bail laws in all jurisdictions. Conduct yourself in all fine manner at all times. Report when and as directed. Be truthful in all statements you make, as well as any answers you give to the probation department about your conditions of supervision. You must keep them informed of your residence and place of employment at all times, and not change either without prior permission. Not permitted to leave the state of Ohio at any time without prior written permission. And if you do, you have to have that pass with you. You may not enter upon the grounds of a correctional facility nor communicate with or attempt to communicate with anyone about in those facilities without prior written permission. That applies to Mr. Hunt. You're not permitted under federal and state law because of your conviction to purchase, possess, own, use, or have under control any kind of firearm, ammunition, or dangerous ordnance. If you do that, that's a felony under both federal and state law, which subjects you to be prosecuted for those violations. It's also a condition you not have any of those items or any other weapons of any type while you're under community control. Now, you're not permitted to purchase, possess, use, or have under your control any type of controlled substance, drug abuse. Let's strike out these two that I normally put in there. Or any variant or analog of any controlled substance that has an effect similar to controlled substances or drugs abuse, or any other instrument, device, or thing that may be used to administer them or prepare them for administration or use, unless you have a lawful prescription, and you must provide a copy of that within 24 hours of receipt to your supervised officer. Required to submit to drug testing when and as requested. You're not permitted to possess, purchase, use, or have under your control any kind of alcoholic beverage or be present in places where the sold, being consumed, being possessed, otherwise lawful. And the reason for that is because, again, we talk about people self-medicating, that's another way of doing it. And it also leads to people in control getting in trouble in other situations, so it's designed to help avoid that situation. You're not permitted to associate with your co-defendant in this case, Mr. Clemens, or any other person that has a criminal record, a member of a gang or other criminal group, or any other person has in the past or in the future associated with a criminal offense to violate these conditions, unless it's proved right by a supervised officer. It applies to any family members other than those who are living with and meeting before the commission is offense. It doesn't include Mr. Clemens. It does include Mr. Clemens. He's not exempt. Now, after the date of this order, you're not permitted to marry or establish cohabitation, common law marriage type relationship with another person without written permission. Anytime you come in contact with law enforcement, or anytime you're charged, arrested, or convicted, or accused of violation of any type of law, you must report that not later than the next business day after it happened. You'll provide your supervising officer financial information records so your ability to pay restitution, fines, fees, and costs under review. If the probation department refers you for an evaluation or assessment or any kind of further treatment, therapy, counseling beyond that you're currently undergoing and ordered by the court, then you'll submit to that. And if there's a recommendation for any type of treatment, then you enroll in a successfully complete that. And I'm specifically thinking about in the event that there's some issue that they think you may have a substance use problem, abuse disorder, then you must include that. Your name, pay court costs of this action, make payment arrangements with the clerk of courts. You'll be required to do 400 hours of community service, 320 hours a week, 20 consecutive weeks unless you're employed, at least 20 hours a week, a full-time student, or you have documentation from a physician or a prior disability finding that you're physically unable to do that. Or you serve 30 days in the county jail. I'll give you time to get ready for that. So here's your report. February the 25th at 4 p.m.
At the jail itself, Judge.
Yes.
Yes, sir.
The bailiff will provide you with an assignment notice for that. And if you fail to report that, it will be considered to be a violation of these conditions. You make monthly payments as ordered by the probation department under restitution. Being placed under community control rather than be sent to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you or used by you, or any other property places under your control where you're found anytime any officer of the probation department. I won't impose any fine. I won't impose any driving suspension. You are ordered to make payment of $890 of restitution to the Hyman County Task Force, which will be joint and several with your co-defendant. Now, what that means is that you're each responsible for the payment of the full amount. But if he doesn't pay his half, you still have to pay the full amount, and you have to go after him to collect that. And he's in prison, so I just expect to pay it off. And then if you want to try to get reimbursement from him, once you got out of prison, then you're on probation, and you can do that. Going back to the additional special conditions, have any contact with Brian Clemens, except as may be ordered by a court for visitation of his child. And that means by a court. That doesn't mean that if he gets out, like I forgot what his prison term is, but if you're still in control when he gets out, you can't let him come see the children, has to be reported before. And thinking I'm being kind of hard on you again, you're right. Trying to help you. He's struggling. He's going to have to take care of himself. But, you, I think, got drugged into this, and I don't think you're the brains behind the thing. I don't know that you're full participant, at least under the evidence that's been presented to me. So all these things are designed to help you keep away from Mr. Clemens so that you don't get drugged back into this. Now, you're also going to pay the court costs as a subject order. To be able to do that, and make payments under court costs as a condition of the community control. And the clerk can't collect that through various means, including levying on bank accounts, waiving earnings, or other assets you may have. That doesn't collect it, then the clerk or the court could order you to do additional community service beyond that I've already ordered. And I will give you credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. Now, in the event that the community or the probation department feels that you have not complied with these conditions, they will file a written notice of that with the court. They'll provide a copy to you. You will be entitled to have a hearing and be entitled to be represented by an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court will revoke community control and sentence you between 9 and 36 months in prison as provided by law and fine you $10,000. If that happens, once you complete the sentence ordered by the court, under the sentencing law, the adult parole authority may exercise an option to put you under post-release control supervision for a period of up to 2 years. What that means is that you'll be supervised by a parole officer under the conditions the parole authority sets, and if they determine during that time that you have failed to comply, then they can return you to prison until you serve the entire term set by the court for an additional period of up to 9 months for any one violation, although there is a cap, a path for whatever prison term you serve for all violations. However, should you be convicted of a felony while in post-release control, then in addition to whatever sentence the judge in that new felony case imposed, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, or whatever time is left on that 3 years of post-release control, whichever is greater. And if that occurs, that must be served separately to the sentence in the case. All right. Is there anything further? I don't see any need to make any order on the car since it's already been done, so, as you pointed out. So. Mr. Wyatt?
Yes, Your Honor, the only question is, I don't believe there's a juvenile case pending related to the child comment. What I was expecting to do, as long as it's okay with you, is anything related to the custody or visitation, bring it through the probation to approve it by
No,
you.
probation department is not a child care or child visitation business. If Mr. Clemens wants visitation, he can petition the court and get it. But anything that might be cooperative between them, I'm not with probation in that business.
I respect that, Judge. I didn't know how you wanted to handle that. I understand. It's
I don't think that way.
It's Mr. Clemens' burden, I think.
It's his problem.
I got you, sir. Okay.
But she, and if the court tells her that it gets visitation, then she can apply, they can have a contact to the extent it's necessary to exchange the child.
I'm on the same page, Judge.
All right.
Okay, thank you, Your Honor.
Anything further?
There you are.
All right, and you get your sign notes there from the bailiff and the report to the jail. On that date, time. Thank you.
Thank you, Judge.
All right, and Mr. Peterson, is that that's going to be by Zoom?
Correct, yes.
All right.
And I think Denny is going to be out at the jail with Mr.
That's my understanding. He told Marcia that.
Denny has the sex offender registration form with him at the jail.
Okay. We did that the other day on that other case. So.
Yes.
All right. All right. I'll give you 5 minutes to. Here, Ben, there's the file. If you want to put that stuff back in the PSI file. Yeah. Hey, Doug, hey, did your dad have arthritis? You look like you get a little attack going around. Just do. I can. Yeah. That way, come on. That's good. Yeah. First four, 22, 4 years old tonight. I'm turning 71. Yeah, I'm turning 71. He was a senior when I was a freshman. My mother is 2 years younger than I am. Now, you're working my daughter. She's always thinking I'm old. Every time I had her birthday, she said, I thought you turned 70 years ago. And you'll live me 74. I got some 3-year-old. 3 years. Yeah. You turn 74, I'll turn 74. You're 3 years ago. I'll see you around.
That's good.
I'll get you back tomorrow just to get others.
All right, let's get this on record.
Recording in progress.
Case number 21 CR 174, State of Ohio versus Jonathan
Douglas Peterson. Are you Jonathan Douglas Peterson appearing there from the jail? Oh, I'm muted, I'm sorry. All right, thank you, sorry about that. Case number 21 CR 174, State of Ohio versus Jonathan Douglas Peterson. And are you Jonathan Douglas Peterson appearing from the jail with Mr. Kirk?
Can you hear us, Your Honor?
I can.
Okay, we couldn't hear you until now. We got the problem fixed on this end.
Okay. Are you Jonathan Douglas Peterson appearing from the jail with Mr. Kirk, there, your attorney?
Yes.
All right. Appearing on behalf of the state is Assistant Prosecutor Adam King. This matter was set for a plea hearing, and Mr. Kirk, you and your client both agreed to have this hearing conducted remotely through Zoom rather than his appearing in person before the court.
Yes, Your Honor.
You're all right with that, Mr. Peterson?
Yes.
All right, Mr. Peterson is charged with 2 counts of rape, first-degree felonies. And I have been presented with a bill of information and a guilty plea form that indicates that defendant is going to plead guilty to rape, I believe, under a different section. Okay. Currently, he is charged under section 2907-02A1B with 2 counts of rape, with the alleged victim being under 10 years of age, which I believe would be a life sentence without parole. Is that correct, Mr. King?
Yes, Your Honor.
All right. Now, I've been presented then with a guilty plea form, Mr. Peterson. This is a 3-page form the prosecutor's office has prepared. On page 3, well, let me hold it up the first page. It shows your name and plea of guilty and case number. I'll hold up the camera there. And can you see that okay?
Yes.
All right. And then on page 3 of this document, there are signature lines, and a little over a third of the way down on the last page, there's a sentence that says, I enter this plea voluntarily, and immediately below that it appears to be Jonathan Peterson printed there, and I'll ask you if you wrote that there as your signature.
Yes, I did.
Right. Now, this agreement indicates you're going to plead guilty to 2 counts of rape under a different section, 290702A2. And both of those are also first-degree felonies, but I believe that the sentence is limited to 11 years. It'd be 3 to 11 years as set by the judge, with the possibility of an additional 1/2 of whatever sentence the judge would impose being added on to that as a maximum. So,
Your Honor, can I intervene? Rape-in-totes does not apply here because of the date of the offense.
oh, okay, thank you. Then I'm mistaken on that. I didn't look at the date. Thank you. So, then it's just a straight, whatever sentence I order will be the sentence that is to be served. And that would be between 3 and 11 years and a fine of $20,000 in each count. You understand that?
Yes.
All right. And it would also require you to be designated as a sex offender, tier 3 sex offender, which would mean you would have to register for the rest of your life as a sex offender with the sheriff, and I'll explain that once we get to that point if we do. You understand that?
Yes, I do.
Okay. And for the record, I did not note this, but there's a person appearing from the victim witness office, and is that the victim's mother or representative?
That's correct, Your Honor. That's Shelley Corrigan. That's the victim's mother.
All right, thank you. All right, Ms. Corrigan, thank you. I just want to make sure that it was record reflected that she was present. It's in the audio-visual record. All right, now, under the law, well, let me back up. Mr. Peterson, when did you sign this plea agreement?
It was last week on the 31st.
All right, and you had your bill of information then?
Yeah.
Okay. And did your attorney go over these new charges with you and explain them to you and what the difference was from the indictment?
Yes, he did.
And did he go over this written plea agreement with you and explain it to you and answer any questions you had?
Yes.
And you understood that by signing that agreement that we're looking at here now, that was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing.
Yes.
And did you have enough time to fully consider this matter before making this decision?
Do what?
Did you have enough time to think about this and before you made the decision?
Yes.
Do you feel that you were pressured or rushed in any way into doing this?
No.
And are you entering into the agreement to plead guilty voluntarily?
Yes.
Again, you signed it last week, and so today is Tuesday. This is still what you want to do, is go forward with this plea agreement?
Yes.
Okay. Now, I want to explain what the bill of information is. I'm sure your attorney's probably explained it to you, but I need to do it on the record so the record reflects that you understand it. The grand jury originally returned an indictment against you for 2 counts of rape, as I explained under the different subsection. The grand jury consists of 9 citizens from this county who meet every month, or as often as necessary, to hear evidence presented to them about alleged crimes in this county. And it requires, the grand jury doesn't make a decision as to whether the person's actually guilty or not guilty. They simply make a decision as to whether or not, based on the evidence that's been presented to them, there's enough to warrant probable cause to have the court or the defendant go before the court to defend against the charge. Since they're not making a decision as to guilt, they only have to have 7 of those 9
members of the grand jury vote to return an indictment. If fewer than 7 vote to indict, then there is no indictment, and the case is over at that point, and the person is released from any orders under that case. Now, case to be represented as long as it's done within statute of limitations, and I think rape there isn't a statute of limitations anymore. Is that correct, Mr. King? I think.
Yeah, I believe that's correct.
Yeah. But in any event, it could be represented. Now, the bill of information that's been presented to me is very similar to the indictment. In fact, it looks very similar because it's worded the same way and the forms are similar, except that the difference is the prosecutor signs the bill of information only. If there's an indictment returned, the prosecutor signs it, and so does the grand jury foreperson to confirm that the grand jury voted at least 7-2, if not 8-1 or 9-0. This precise number is not on the report, but there were sufficient number of persons that voted to indict to return the indictment. And so the grand jury has not met to consider these charges. And so under the law, you're not required to come before the court to answer to these charges until the grand jury has returned an indictment. And that hasn't happened yet. The grand jury met earlier last week, so they're not scheduled to meet until the first Tuesday in March, whenever that is. And so you're not required to come before the court on these charges. Now, that being said, you can waive the right to have your case presented to the grand jury. Waive means to give up. And so I have been presented with a form that's entitled Waiver of Prosecution by Indictment. And that form reads, I, Jonathan Douglas Peterson, having been informed by the Court of Law and Constitutional Rights my right to be prosecuted by way of indictment, being represented by Dennis Kirk, attorney at law, Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment, agree to proceed in this manner by bill of information. It's dated 1/31/22, and is that your signature there, right below that date there, Jonathan Peterson?
Yes, it is.
Okay. And so when you signed this, your attorney went over it with you because his signature's right below.
Yes.
And he explained it to you.
Yeah.
You understand that by signing this form, you're saying to the court that it's all right for you to be prosecuted in this fashion rather than waiting for 3 or 4 weeks for the grand jury to meet and indict you.
Yes.
All right. Now, under the law, as I mentioned, the maximum sentence on each charge is 11 years, minimum is 3. The court could order those to be served consecutively if you are convicted of both. So that means that you would be facing a total maximum sentence of 22 years. And if the minimum sentence is current, then it would be 3 years. You understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control from any jurisdiction?
No.
Right now, under the law, Mr. Peterson, if you plead guilty to these offenses and are sentenced to prison, once you complete the term of imprisonment ordered by the court, the doctoral authority may choose to put you in what's called post-release control supervision for a period of up to, they have to put you under 5 years of mandatory post-release control supervision. So what that means is that, excuse me a second. What that means is you'll be supervised under terms set by the parole authority for 5 full years after you are released from prison. If during that period of time you violate any of the conditions that they impose, because the judge doesn't have anything to do with that, then they can return you to prison, even though you serve the entire term that was ordered by the judge, for an additional period of up to 9 months for any one violation, but there is a cap or limit of half of your prison term for 1 or more violations. However, if you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge in that new felony case would impose upon you, that judge would also sentence you in this case for committing that crime while under post-release control supervision to an additional period of 1 year or whatever time is left on that 5 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in that new case. You understand that?
Yes, I do.
Now, the bill of information, count 1 reads, that on about the period of June 1, 2014, continuing through August 1, 2014 in Highland County, Ohio, You did engage in sexual conduct with a person identified by the initials AW, and that you purposely compelled AW to submit by force or threat of force. Violation of section 2907.02A2 of the Ohio Revised Code, rape, felony of the first degree. Then count 2 alleges the same thing, same date and time. Right. So those are the charges against you. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes.
And have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible defenses you try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs there at the jail?
No.
Have any arrests been made to make you plead guilty here today?
No.
All right, now on page 2, there are several sentences that are printed in bold and underlined. I'm going to hold those up to you. That's on page 2. You recognize those?
Yes.
All right, I will read that in the record. Finish owner pleaded guilty to count 1 and count 2 of the bill of information. State and defense jointly recommend 8 years incarceration on count 1, consecutive to 7 years incarceration on count 2, for a total term of incarceration of 15 years. State will dismiss the charges outlined in the indictment. Defendant shall be a tier 3 registered sex offender. Now, is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Under the law, Mr. Peterson, the matter of sentence is up to the judge. So even though there's a recommendation that you receive a total of 15 years under the possible 22 years for the 2 offenses, I'm not obligated to follow that recommendation. And so if you are convicted of these 2 offenses, once I've heard all the information, if I decide that's not the appropriate sentence, I can give you any sentence I think is appropriate between 3 and 22 years. You understand that?
Yes.
All right. Now, do you hold any license or certification from any state agency or regulation of any trade or profession?
No.
Right now, you have certain constitutional rights, you must understand before I can accept your plea. First, you have a right to have an attorney, and I appointed Mr. Kirk to represent you since you did not have the funds to hire your own attorney. Now, he was not appointed simply to work the case out, but present any defense on your behalf that might be available to you under the law that you wish him to provide. So if you decide you don't want to plead guilty, you're still going to be represented by Mr. Kirk. He'll still defend you against the charges, including a trial on the charges in the indictment, if that's what you want. You understand that?
Yes, I do.
Right? Now, before I go any further, skipped over this. I see that the victim's mother is present, and Mr. Kane, you consulted with her and regarding this disposition of the case.
That's correct, Your Honor. I spoke to her on January 27th, and she approved of this agreement.
All right. And that's still the case, ma'am? You just shake your head?
Yeah.
Oh, you're muted. Okay, thank you. All right. Now, Mr. Peterson, you have a right to have a jury trial on these charges in which 12 people would be selected from a group of citizens who live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. The judge will instruct them on the law, and then that jury will decide by unanimous verdict, meaning all 12 have to agree, as to whether or not the state proved your guilt of these charges. And those verdicts would have to be unanimous, meaning all 12 jurors would have to agree as to a verdict on each of the 2 charges. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which is similar to what you've already done on the indictment. Again, waive means to give up, and that means you would give up the right to have a jury trial. And then in that case, the court would conduct a trial, so the judge would hear the evidence instead of the jury. The judge would be the one who would decide whether or not the state proved your guilt by proof beyond reasonable doubt on the 2 charges after considering the law. You understand that? I'm sorry to hear you.
Yes, that's okay.
Sorry, somebody makes some kind of noise there. All right, now, under the Constitution, Mr. Peterson, you have the right to confront your witnesses against you in these cases, in these charges in open court. What that means is that, and to cross-examine for your attorney. What that means is that those jurors would have to come into this courtroom and testify in front of you and your attorney and anyone else who might be present. After the prosecutor's done asking questions, your attorney would ask questions. That's what cross-examination is. And that is designed to try to bring out evidence that helps your side of the case. You understand that?
Yes.
Under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certified to come in voluntarily, your request according to the court order is called a subpoena, and force those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes.
Under the Constitution, Mr. Peterson, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one can even talk about it with one exception. That is, if there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes.
All right, now, Mr. Peterson, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense by proof beyond reasonable doubt. That means that the burden isn't on you to try to prove that you're not guilty simply because you've been accused of a crime. In fact, under the law, you're not required to present any evidence of your own defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
All right, now, originally entered plea of not guilty. That plea denied the allegations in the indictment, denied you committed any crime, and they exercised or invoked all the rights that I just described for you. Now, if you change your plea from not guilty to guilty on these two new charges, plead guilty instead of not guilty, that's the opposite of the not guilty plea. Guilty plea admits the allegations in the indictment, admits that they are a crime, and that you committed that crime in each count. And that plea waives or gives up all of the rights that I've just described for you here in court, except your right to have an attorney, because you always have a right to have an attorney no matter what your plea is. So with that exception, your plea of guilty waives gives up your right to have a jury or court trial, waives gives up your right to confront the witnesses against you and cross-examine with your attorney, waives gives up your right to use the power of the court to compel or force witnesses to come to court to be able to testify on your behalf, the same as the state. Waives gives up the privilege against self-incrimination, because if you're saying you're guilty, that's what you find you guilty. And waives gives up your presumptive innocence, because if you say you're guilty, the state doesn't have to prove you guilty. It also waives gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence or under certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. And finally, it does subject you to being sentenced immediately by the court, which is what's likely to happen here if you plead guilty today. You understand all of that?
Yes.
Mr. Peterson, are you a U.S. citizen?
Yes, I do.
All right, now, do you have any questions about the bill of information or the waiver of indictment that brings you before the court on these two charges?
No.
You understand?
Yes.
Do you have any questions about the charges in the bill of information?
No.
You understand it?
Yes.
Any questions about the plea agreement?
No.
You understand it?
Yeah.
Again, you understand the recommendation on sentencing isn't binding on the judge.
Yes.
You have any questions about the constitutional rights I've explained to you?
No.
You understand them?
Yeah.
You have any questions about the plea of guilty, what it means, what will happen at the end of that plea here today? You understand?
Yeah.
Is there anything you'd like to speak to Mr. Kirk about before we go any further?
No.
All right, then, Mr. Peterson, is it your decision to withdraw your not guilty plea and to plead guilty to the bill of information in count 1 and count 2, rape under the 290702A2 section, pursuant to the terms of the written plea agreement that I've just gone over with you? Pardon me?
Yes.
Okay, thank you. All right, then, as to the count in charge of count 1, which reads in on or about the period of June 1, 2014, continuing through August 1, 2014 in Hyman County, Ohio, you did engage in sexual conduct with AW, and that you purposely compelled AW to submit by force of threat force, violation of ORC section 290702A2, rape, a felony of the first degree, carrying possible prison term between 3 and 11 years, and a fine of $17,500. How do you, I'm sorry, $20,000. How do you plead?
Guilty.
And also will subject you to mandatory registration of sex offender for the rest of your life. You understand that?
Yes.
Okay. Then is count 2, which alleges the same offense occurred in the same time frame, different act, but the same charge, same penalty, rape, first-degree felony. How do you plead?
Guilty.
All right, thank you. The court finds on this date of the court, defendant was advised of his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Rule 11, please accept the court filed. Defendant is found guilty of each of the first 2 counts in the bill of information. The 2 counts in the indictment will be dismissed. Court will not order a pre-sentence investigation and proceed with the court. Before we do that, I must do the sex offender registration notification. And you have that form there in jail, Mr. Kirk?
Okay, we do, Your Honor.
All right. I'm going to run over this with you and explain it to you, Mr. Peterson. And just kind of follow along there on the form that Mr. Kirk has. All right. Because of your conviction for 2 counts of rape, you are hereby designated as a Tier 3 sex offender, child victim offender registrar. You're required to register in person with the sheriff of the county which you establish a residency within 3 days of going into that county, or if you're going to be staying in that county more than 3 days temporarily. You're also required to register in person with the sheriff of any county where you may establish a place of education as soon as you go into that county. If you establish, if you are working in another county for more than 3 days consecutively, or for a total of 14 days or more in a calendar year, then you'd be required to register in the next county as well. So you would be subject to registering up to 3 counties where you're living, where you're going to any kind of educational programming, and where you are working. For purposes of registration, work includes doing community service or volunteer work. Now, in the event that you move to another state, go to work in another state, or move to a place of education in another state, you'll be required to register with the sheriff, the county in that state, or other officer that is charged with the responsibility under that state's law with maintaining sex offender registration information. You're required to provide the sheriff any temporary lodging information, including the address and length of stay if you're going to be absent for more than 7 days. So, if you're going to be visiting family, going to be in the hospital or some recuperation or something for 7 days or more, then you must let the sheriff know where you'll be, what the expected time will be. Now, if you change your place of residence, employment, or education, you have to provide notice of that change to the sheriffs and the counties in which you're registered. You must do that before you move into another county. You have to notify the sheriff of where you're living. And you must do it at least 20 days prior to making any change in any educational programming change. Now, as far as employment is concerned, you have up to 3 days you can do consecutively, but after that, you must register if it's more than 3 days. If at any time you are homeless or have no fixed address, you'll give a complete description of the place or places you'll be staying. And as soon as you do have a fixed address, you must notify the sheriff not later than the next business day after that occurs. Under federal law, you must report any international travel and at least 21 days before traveling, and if you don't do that, you can be subject to prosecution. Now, you are designated as a Tier 3 sex offender, which is a lifetime registration requirement, which means you must register every 90 days for the rest of your life once you're out of prison. And you can't register any earlier than 10 days before your verification date. So it's going to be every 80 to 90 days that you have the window to register. You must do that in person. You can't do it by phone or email or text. You have to do it in person and show up at the prosecutor or at the sheriff's office to do. Now, your expected residence, I assume, is going to be in Highland County, Mr. Kirk?
Yes, on the form out here, you have me list 352 Johnson Street, lot 30, Hillsborough, here in Highland County.
All right. So that means that you would be required, once you complete your prison sentence, to register with the sheriff, there at Homestead Drive in Hillsborough, no later than 3 days after you're released to come into the county. And if you, I already told you, if you fail to register, or do anything you're required to do that I just explained, then you could be subject to criminal prosecution under chapter 450 of the Ohio Vice Code. All right, now, that completes the explanation of Mr. Kirk. Has he signed that agreement there yet?
Yes, not yet. I waited till the court revised it.
Thank you. All right, if you can have him sign it, then that, while we're on the record.
Okay. Anything that just explained this form? And today is February the 8th. Let the record reflect, Your Honor, he did sign and date that in front of my presence as well as one of the corrections officers.
All right, thank you. If you would deliver that to the court so that I can sign it and file with the case, then I appreciate it.
I will.
All right. Now we'll proceed with the matter of sentencing. Anything from the state?
Only was contained in the plea agreement, Your Honor. Also, Shelley Corrigan would like to make a statement if the court permit. Thank you.
All right, that is your right. And so, Ms. Corrigan, if you would state your name, spell it for the record, and then I'll hear whatever you would like to say.
My name is Shelley Corrigan, SAGLLYCORRIGAN.
Go ahead.
My daughter's scarred for life now. He took her NC away from her. And she's been cutting herself. And she has to go to therapy every week. And it has torn me and his father a lot of hurt. I mean, I watched you grow up. I've been with his dad for 10 years. Now my daughter's scarred for life. And it's really just emotional. It's messed our lives up totally. And it's not fair. He should get the maximum.
Anything else
That's
you'd
all
like
I
to
got
say?
to say.
Okay. All right, so the victim, is this his niece?
It's his stepsister, Your Honor.
Stepsister, oh, okay, gotcha. Thank you. All right. Kirk?
Thank you, Your Honor. This is my client's first felony. I believe it may be his first criminal conviction at all, including misdemeanors, but definitely first felony. It was committed when he was 17 years of age. He's now 25. So since that time, there's been no additional crimes. Had he been tried as an adult or a juvenile, it would have been reported at the time. He probably would have done about 3.5 years in Department of Youth Services potentially. So in this case, I don't think the proposed sentence is overly lenient or anything of that nature. He did confess to the police and cooperate with the investigation, and he saved the victim from testimony and further embarrassment by admitting to these charges today. So would ask the court, in light of all of those factors, to follow the agreement with the 7 years on the one count and 8 years on the other, for a total of 15 years. Thank you.
How old was AW at the time of these offenses?
He was 7 years old, Your Honor.
And he was 17?
That's correct.
Yes.
All right. Anything further?
No, Your Honor.
Mistake.
So AW is now, what, 14?
Either 13 or 14.
Ms. Corrigan?
She is 14.
14 now. And what grade of school is she in?
She's in 8th grade.
Thanks. All right. Well, Mr. Peterson, this is crime of rape and murder, I suppose, most murders at least. This is the most serious offense to be committed in the courts of judgment. It's the cruelest form of child abuse that there is. It's a family member, somebody that you're growing up with. I understand you're only 17 when you did it, but that's not much comfort to her. And the things that this Gordon is describing are very common results and after effects of the harm that's caused by this type of conduct. You were charged with something that could have given you life imprisonment without any possibility of parole. My hunch is, my inference based on my experience, both as a prosecutor for 24 years and now as a judge for almost 14, is that this plea agreement was done to spare the victim. And so, to that extent, the court takes that into consideration that you haven't done that. But on the other hand, it also has significantly reduced what you could have, you admitted in prison for the rest of your life. No question about that. These charges would not have most likely stayed in the juvenile court, because even if somebody commits a crime as a juvenile, at the age of 17, that crime can be backloaded to the court and the person tried as an adult and subject to those penalties. So all that being said, I do appreciate the efforts that went into this agreement and the concessions that each side made. But in view of the court, I think that there needs to be a different sentence. So it's for the court that you be and are hereby sentenced on count 1 for a period of 9 years and count 2 for a period of 9 years. Those sentences are to be served consecutively to each other for a total of 18 years. The court feels that the sentences, these offenses were committed as part of a normal course of conduct, and the court's finding is that one single sentence would not adequately reflect the seriousness of the crime, the impact on the victim, and the sentence is not disproportionate to the seriousness of this crime, because, as I said, it's an extremely serious crime. The court also feels that even though these are your first 2 convictions, having committed 2 rapes is sufficient criminal history to demonstrate that there is a danger to the public. And I'll just make that statement because, in my experience, going on now 46 years in this business, the people who commit sexual abuse against children seldom do it once, seldom have only one victim. Now, I don't have any evidence that you have any other victims, but the other thing I'll say is that the treatment of sex offenders over the last 4 years has met with limited success, as defined by recidivism, and persons who commit these kinds of offenses are simply dangerous. That's why we have sex offender registration, and that's why that provides that persons that live in proximity to those offenders that are registered are entitled to be notified, particularly if they have children, so that they can take steps to make sure that they're protected. So there's just simply a great risk there, and so that's another reason that the court is opposing consecutive sentences. And the court also noted that for the record, the plea agreement recommended consecutive sentences as well, although the court chose to impose a greater sentence than that recommended by the parties. You're also, according to this, the sheriff's department, you were arrested on September 1st, is that correct? Right, that's 141 days in of jail time, correct? Now, upon completion of this sentence, you will be required to be in a close release control supervision for 5 full years under the supervision of probation and parole officer under the term set by the parole board. If during that period of time they determine that you have failed to comply, they can return you to prison even though you serve the entire term imposed by the court for an additional period of 9 months for any single violation, but there is a cap of half of your prison term, which in this case would be 9 years for all violations. However, if you commit a new felony on post-release control supervision, then in addition to whatever sentence the judge in the new case imposed upon you, the judge could also sentence you for committing that felony while in post-release control supervision in this case to an additional period of 1 year, or whatever time is left on that 5 years of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Also, order to pay the court costs which judge grant execution is ordered. If you fail to do that, then upon completion of your prison term, not longer in prison, but once you get out, court can order you to be serviced in this county and give you credit for each hour you work in an hourly rate set by the court, and each hour you work would be credited to that judge until paid. All right, is there anything further to counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded to custody to be conveyed to the institution. Mr. Reed. Thank you. All right, Mr. Nunn, you want to come over here and have a seat? You have the paperwork there, Mr. Dan, did you go get that?
Clerk Court?
Full, entry to, oh, go ahead. This is secondary felony.
It's a judicial release, sir.
Pardon me?
There was a judicial release that came through in the recommendation for drug court.
Well,
I did not.
that's one mistake. Can't do it. Secondary felony, sorry. I didn't realize that.
I didn't.
Just recently with the thought, yeah. I apologize, because I would like to have you in the report, but under the standards in the court, where second and first degree felonies aren't eligible. So rather than well, I can't do it now. I apologize. I didn't think about it.
I didn't catch it either,
I
sir.
looked at it.
Yeah,
Didn't think
I
about
didn't
it.
catch it.
The only thing I can say is that, maybe you can work with probation department and your department to give him similar services. And if you want to come to drug court and observe, you can certainly do that. Given the disqualification, I can't change that. I'm really sorry, Mr. because I think otherwise you'd be, I think that's why I said that at the time, because I thought with your history, you'd be an excellent candidate without thinking at the time about the offense, because most of the attempted burglaries we get are third-degree felonies. And that's probably what I was thinking at the time. I didn't look at the plea closely enough to realize that. And so, that's the bad news. The good news is I don't normally grant judicial release to second-degree felonies. Very few. You're one of the few, probably less than 5. Because I think that you've got it in you to be successful and be sober. I wish we could give you the full resources of the drug court, but there are a lot of things in this, because Ms. Sturgill, Ms. Davis, and the department do work, with people intensively when necessary. So I would say that would be something if you might want to do. So I apologize for that. And I've had a lot of things on the plate, and I just haven't had time to keep up with things. And today I had a disruption. My schedule started yesterday, today, and I had to stay home to come and didn't have a chance to look. I didn't have these files with me to look at. The day before, I got home yesterday. He was supposed to be there yesterday, and he looked there. Finally called me about 5 o'clock, saying I got home morning. I said, yeah. So I apologize for that. But I will say this: I am glad that you were willing to try this, and I don't want you to be discouraged. Because I would have put you in the program if I could. No question about that. I think you would meet the criteria other than this, this disqualified. Like I said, I should have looked at that more closely. And, it didn't happen, so I'll take responsibility for that. And don't be discouraged, you made good progress, since you've been out since, about 3 weeks now, and this is the most dangerous time that there is for relapse. You've done this before, you know that. And they'll be there to improve as much as they can. So, but, just, keep trying.
All right, thank you, sir.
All right, thank you.